Hello friends, in the series on the income tax cases, today we will discuss a very important case. The name of the case is CIT TDS versus Tata Teleservices Ltd. This case has been decided by Honorable Delhi High Court and the case has been reported in 456 ITR at page number 691. The date of the judgment is 30th May 2022. In this case, a very limited issue was before the Delhi High Court. The issue was whether the assessee has to pay the TDS, or in other words, the assessee has to deduct the TDS in case of payment of Interconnect user charges to various telecom services, to various telecom companies. When this matter was before the Delhi High Court said that in a case that is CIT TDS versus Vodafone South Ltd, the department has taken a conscious decision not to file the special leave petition against the judgment of the High Court on the basis that in that case it was decided by the department that in various cases which have been decided by various high courts, it has been decided that the TDS should not be deducted in case of Interconnect user charges paid to various telecom services, access port charges and roaming and data related charges paid to various telecom services. Meaning thereby that in the case of CIT TDS versus Vodafone South Ltd, same issue was there, and in that issue when it was decided in favor of the assessee on the same matter, the department has taken a conscious decision not to file the SLP on the merits of the case. So the court said that when the department has chosen in one case not to fight the case, it means that the issue has been settled and now the department in other cases also cannot contest the same issue. The court also gave reference to the various decisions in which it has been held that when the department chooses not to file the SLP on the merits of the case on some issue, then on the same issue the department cannot go for litigation in other cases also. Those cases are Birla Corporation Ltd versus CCE 2005, CCE Amar Bitumen and Allied Products Pvt Ltd, Berger Paints India Ltd versus CIT. In all those cases, this issue has been settled, and by taking the shelter of these cases and the very conspicuous decision taken by the department in the case of CIT TDS versus Vodafone South Ltd, the same issue was before the court that there is no TDS requirement on Interconnect user charges to various telecom companies. Friends, as far as the issue that whether the TDS is to be deducted in case of Interconnect user charges, although this issue is being settled in this case, but apart from that, the more important thing which emerges from this case is that if we are able to find out the matter on the issue which we are fighting on some issue in the courts, that on the same issue already the department has taken a conspicuous decision not to contest that case because of the merits of the case, then by taking the shelter of that case we can convince the court that this issue has been settled in favor of the assessee and the department has chosen not to contest the case. Because it has been very routinely observed that the department files the petitions before the various tribunals, high courts and Supreme Court just for the sake of filing these appeals, due to which a lot of energy, a lot of resources are being wasted of the department and of the courts, and at the same time of the assessee also. Friends, at the end of this video, once again I am repeating the name of the case. The name of the case is CIT TDS versus Tata Teleservices Ltd, and this case has been reported in 456 ITR at page number 691. The matter has been decided by Delhi High Court and the date of the judgment is 30th May 2022. Thank you, friends.